further, my name is Dominica Essie. I'm the CLE and Sections Manager here at the Cleveland Metropolitan Bar Association. If you are tuning in to today's program for CLE credit, you have to complete the polls that will be administered throughout the program today, as well as complete the brief survey that will be sent following the program. Certainly, today's program is meant to be interactive, so enter your questions into the Q&A function at the bottom of your screen. You can also communicate with us through the chat as well. And with that, I will turn it over to our program moderator today, Frederick Cruz. He is the incoming chair of our litigation section here at the CMBA. Thank you for being here, Freddie.
Thanks, Dominica. Good afternoon, everyone. As Dominica said, I am Freddie Cruz. I am corporate counsel for litigation at the Sherwin-Williams Company, and I'm in my first month as the chair of the litigation section for the CMBA. We've got a pretty interesting program for us today. Justice Donnelly is going to be our presenter. As Dominica mentioned, we do want this to be interactive, so we've saved quite a bit of time at the end for questions. So please do take advantage of the access you have today. Use the Q&A or chat function to include any questions you might have. We also have a poll that Dominica is going to pull up right then, just to kind of get an idea of everybody in attendance, how they feel the issue that we're going to be discussing today is, as far as, you know, whether it's a problem or not. So if you could go ahead and do that now. Okay. Hopefully you've all entered your answer there on the poll. And with that, I'd like to introduce our speaker today, Justice Michael P. Donnelly of the Ohio Supreme Court. As most of you know, Justice Donnelly served as a judge on the Cuyahoga County Common Pleas Court for 14 years, from 2014 through 2018. And in November of 2018, Justice Donnelly was elected to serve as the 160th Ohio Supreme Court Justice. Justice Donnelly asked me to keep his introduction brief today, so I won't elaborate much more than that. And I'll give him the opportunity to dive right in. He's got a lot to talk about, and he's very eager to share his thoughts with you today. So without further ado, Justice Donnelly, take it away.
Thank you very much, Frederick. Can you hear me okay?
Yes.
Good afternoon to everyone, and thank you very much for attending. I'd like to thank the CMBA for allowing me to present on this topic that I feel very strongly about. There is a form, it's not really a rule, there's a form that has been created to address unreasonable delay that you may be finding in your case, wherever it is in the state of Ohio. And the entire Supreme Court unanimously voted to at least put it out for public comment. So I'm going to talk about the context of how this came to be, why I feel so strongly about it. I'm going to go through a PowerPoint that I created, and then hopefully we can have some discussion. And if you are in favor of this effort, which I hope you will be, I'm going to encourage you to send public comment in before the comment period to Colleen Rochard, who is the manager of the case management section at the Ohio Supreme Court. So I think before beginning the PowerPoint, I'd like to relate to you an anecdote that basically describes what I've often said is one of the biggest epiphanies of my career when I served for 14 years on the Common Pleas trial bench. And it involved a out-of-state CLE that probably 7 or 8 of my colleagues have been on the Common Pleas trial court in Cuyahoga County, signed up for, and we flew down to Williamsburg, Virginia, and we spent 3 days listening to judges from all over the United States, and as well as took in surveys that they had compiled, basically studying jurisdictions where the litigators, the lawyers, the citizens had the highest degree of public confidence in their justice system. And I don't think it'll surprise many of the litigators on this webinar that what they found was those jurisdictions that provide the litigants with the highest degree of trial date certainty and ruling date certainty is where they have the highest degree of public confidence. So I remember flying back and talking to my colleague and friend, Judge John Russo, who was just about to become administrative judge a few years later, and commenting, I said, isn't it interesting that what we learned down here over these 3 days is something we really kind of intuitively or instinctively knew from trying to manage our civil docket. And I came back with a renewed commitment to try to improve my case management, to eliminate all unreasonable delay. And I vowed that I would work with the lawyers, particularly at the CMBA and with this litigation section, to try to combat what I thought was a problem. I just saw the poll results and that they were interesting. Most of them were strongly agree it is a problem. There were a few slightly disagree that it is a problem, but there were no responses that it isn't a problem. So what is going to be created is part of an effort that I'd like to see. I've given it a name. It's called the Maximum Efficiency Initiative. And hopefully you see this PowerPoint on your screen right now, which I'll go through. Okay. If you've heard me speak before on the justice system, whether it's criminal justice system or the civil justice system, I've often said that I believe transparency, the ability for the public or the attorneys practicing within the courts is the single most important factor in ensuring that the judicial system works as designed. The ability that cases are proceeding, they are getting resolved in the most efficient way according to the merit or the lack of merit of the claim. This initiative that I envisioned, and when I was fortunate to win a seat on the Ohio Supreme Court, I vowed that I would do my best to deal with what I see as a problem and what I hear from litigators constantly is a problem in our system. And it's not surprising when you have a system that's made up of human beings who operate in different fashions. But I think as a judiciary, we need to make a commitment to deal with what I consider the biggest threat, particularly in the civil justice system, but also in the post-conviction criminal section, where lawyers who advance claims of innocence are trying to get a second look at the case. And that is, of course, delay. We've all heard this before. Famous Gladstone quote, "Justice delayed is justice denied." And I firmly embrace this as a trial court judge for 14 years. And all the litigators know this, every case involves people who are in conflict, and conflict causes stress in people's lives. And when the main function of the judiciary is to resolve claims, we should have a commitment that we do that, resolve every claim, no matter how simple, no matter how complex, in the most diligent, efficient fashion that we can. So just to give you an idea of how long I've been thinking about this issue, this is a picture of my son about to go up to bat when he was in Little League. Right now, he's now entering his sophomore year at Ohio State. So that'll give you an idea of how long I've been thinking about this. But it involves an anecdote when I was watching him play one time. And one of the grandfathers of one of his teammates walked up to me. He had found out that I was a judge, a trial court judge on the Common Pleas Court. And he said, "Hey, you're a judge, right?" I said, "Yes." He said, "Can I talk to you about a case I have some problems with? It's actually a case involving my son." And I said, well, is it a case on my docket? Because I'm not prohibited to talk to you about it if it is. He said, no, it's actually in another neighboring county. I said, yeah, sure. Well, what seems to be the problem? And he said, well, my son wanted to build an addition to his garage in the backyard, and one of the neighbors had a problem with that. And so they objected. And so they had a hearing at the local zoning board. And they hashed out all what the law was and was this permitted. And the son ended up winning the right to build his garage. And the neighbor appealed this in the form of an administrative appeal into the local Common Pleas Court. And it had been fully briefed by both sides. And it sat there for nearly 3.5 years with no future event scheduled, no ruling date. And I knew the judge who was on it. I got to know the judge at conferences, various conferences. I was very active in the Ohio Common Pleas Judges Association, and he was a good judge. And he had a reputation for fairness. And I thought, well, how do I address this? And I thought, well, I could call him and give him the case number, but he might take offense to that, or he might try to glean that I was trying to push him one way or the other on how he should rule rather than just rule. So as fortune would have it, I had just been on a panel discussion with, unrelated to this topic, with the disciplinary council at the time. And so I called him and I said, look, would you do me a favor? I explained the situation to him. I gave him the case number and I said, would you mind calling this judge and just let him know that, it might be fallen through the cracks. Can he take a look at this case? And don't tell him where it's coming from. Don't tell him how to rule, just rule. And he said, the first response was, we don't really do that. First of all, how we operate down here is you have to file a complaint against the judge. Then we give it a case number. Then we set a letter of inquiry. We don't just make casual calls on these matters. And I said, look, he does not want to file a complaint against the judge. He does not want a disciplinary action to unfold out of this. He just wants a ruling. And after somewhat lengthy discussion, he finally said, look, I'll do this just once. Have the grandfather send me a letter or a card explaining what you just explained, and I'll make that call. And so I went to the next game. I gave the information to the grandfather. And 2 weeks later, I saw him. He was all smiles. And he told me, great news, the case had been ruled on and his son could finally build his garage after now 3 years of waiting, which if he didn't act and by happenstance met me, may have just continued to languish on the court's docket. And it got me thinking, there's got to be a better way of dealing with delay. And even as I continued to see incidents of the delay in Cuyahoga County, I would deal with it in a similar fashion. Every now and then I would get a call from the Ohio Public Defender's Office, and they have a wrongful conviction unit, and they were talking about their claims, motions for a new trial, because they wanted to demonstrate that new evidence had been developed that undermined the theory of guilt that was used to convict the defendant originally, and they deserved a new trial. And it was fully opposed by the prosecutor's office, and it was ripe for ruling either way, one way or the other. But there was no scheduled event on it. And in some cases, it had been pending for 2 years. And so how I would deal with this at the time, I would call Judge Russo, who was the administrative judge, and my friend, and who attended that seminar in Williamsburg with me. And I said, John, can you go talk to Judge so-and-so and let them know about this? And again, don't tell them how to rule, just rule, so that the parties can move on with the case. And that's how we would deal with it. But again, it was happenstance that these people were able to get the case moving. So I vowed, when I was fortunate to win a seat on the Ohio Supreme Court in 2018 and starting in 2019, that if I could do something, create a process, create a program to deal with this problem, I would do it. And I started having meetings with now disciplinary counsel Joe Caligari, and I told him what I would like to see happen with the courts. And to my great surprise and good fortune, he told me he had made some inquiry with the case management section of the Supreme Court, which I didn't know. It was established in 1997 by Superintendent's Rule 35. They have a full staff, and Colleen Rochert is in charge of it. And what I learned was what I was envisioning in terms of another way of dealing with this delay, of contacting the delay, had been occurring already for years. That people were upset with not getting rulings on their motions, a lot of motions for summary judgments, or even verdicts from bench trials. They were frustrated because nothing seemed to be able to move it. And so I talked to Colleen. We had a series of Zooms, and she said, yeah, we've been doing it forever. I mean, she said the problem is we don't really have teeth. We don't have a unified court system, but most judges, and I don't find this surprising, most of my colleagues that I worked with are conscientious, good, hardworking judges. And if they're alerted to an issue that needs to be ruled on, it seems to me that just a phone call would get it going from the Supreme Court. So I said, if this has been going on for years, why don't we formalize it? Why don't we create a process? And then why don't we advertise it so that the attorneys know about this? So I provided the administrators with some written materials. When I was still on the court, I worked with the CMBA litigation section, some great attorneys on both sides of the aisle, plaintiff and defense. And we tried to address this issue locally in Cuyahoga County. And we tried to create a new rule that I borrowed from a rule that already existed in New Jersey that the judges had all approved. And it was a rule that if a motion for summary judgment was filed in a case and it was fully briefed and opposed on both sides and it was ripe for ruling, that we would provide the attorneys with a ruling date that they could count on that was set far enough in advance of the trial date so that potentially unnecessary litigation trial preparation expenses did not need to be expended either way. And if the parties did not receive a ruling by the ruling date contained within the case management order, and they didn't receive an explanation as to why, maybe perhaps a valid explanation might be, hey, I'm in a busy murder trial right now, I can't get to this, but you'll get your ruling next Friday or something like that. But if you didn't receive any notice from the court at all, the parties would receive an automatic continuance of the trial until the motion was ruled upon. And I just thought this was common sense. I thought it would pass with flying colors. But to my frustration, when I presented it to the court in Cuyahoga County, it was voted on by a majority of my colleagues on the court just to table it, and we never revisited it. And so that was that. So why am I revisiting it now at the Supreme Court? What do I think we can accomplish? Well, one thing that gives me a lot of optimism is meeting with new judges who are just joining the bench for the first time and learning about case management and learning about transparency and how important efficiency is to the litigators and their clients. So what my vision is this maximum efficiency initiative will be a combination of both judicial education for new judges, but also judges who have been on the bench for some time, and even some older judges who might buy into this, what we're going to be talking about today. So judicial education, and then what I wanted to see was a new process to address specific instances of delay. Now, this process that has resulted in this form that is being put out for public comment doesn't exactly mimic what my initial proposal, but I'm willing to take half a loaf other than no loaf at all. But let's start with what I see we need to do with our new judges, our existing judges, in terms of proper civil case management. I'll be interested to hear from the litigators if you agree with this. So you have a civil complaint filed, and then by rule, as everyone knows, the answer is filed, generally denying the aspects of what's been alleged in the complaint to whatever extent. And there you have the dispute that is assigned randomly to one of the judges on the court where you're filed to resolve that case in an efficient, in the most efficient way possible. Case management conference. I think if we've learned one thing, the silver lining in this terrible pandemic has been that unless one of the parties asks for good reason to appear in person with a judge, we should abandon that practice for good. And I think that we should do most 99% of all case management orders on a Zoom call so that people can enter a case management order and have dates set. I firmly believe if we had every one of the 400 or so common pleas judges operating under the same uniform case management order, we could get a lot more efficiency out of the system than we do at present. So, and that in your materials emailed to you was what came of that effort in Cuyahoga County, the CMBA endorsed case management order, which was created by efforts of every lawyer on that litigation panel on both sides of the aisle. So take a look at that, because after the effort to change the rule in Cuyahoga County failed, what I did was I just put the CMBA endorsed case management conference order on my website, and so did about 8 other judges. And so this is what we do. This is how we operate for every civil case, no matter how simple, no matter how complex. So in my management of my civil docket, no one left the case management conference without receiving a trial date. And if they anticipated dispositive motions, they received dispositive motion dates set far enough in advance of the trial date. They also received a ruling date that they could count on once the dispositive motions were fully briefed. This is how I believe we need to train our judges with regards to what happens after the case management conferences that every litigator knows. Inevitably, you're going to encounter discovery disputes. What I did after studying different methods of trying to eliminate delay is try to eliminate the necessity of parties filing motions to compel or motions for protective orders if they involved a discovery dispute. And what I would tell the parties at the case management order, and it was built in, if you have a discovery dispute, you contact my staff attorney and you will be either on a phone call with me, or if you so like to come down to the court and make a record, I will have you down here and we will resolve that dispute within 48 hours. And most when I started doing this, a lot of my colleagues would say, aren't you going to be on the phone every single day with people engaged in discovery disputes? And it was exactly the opposite. When you provide this degree of accessibility to the litigators, they only come to you with really substantive issues that they just can't work out for various reasons. Most of the time, attorneys will work out the disputes themselves when the neutral in the adversarial system provides that degree. And it resulted in, I would say, estimating 10 phone calls a year. Most of the time they were relevance based. I want this, it's relevant to my claim and they won't give it to me. No, it's not relevant and they don't deserve it for whatever reason. We would hear both sides out. Ruling would be made, either give it to them or don't give it to them. And that case would move on without the expensive filing a motion to compel or a motion for a protective order, which simply causes delay. Every now and then, and this was the small percentage of cases where, you know, there might be a privilege what they want is work privilege. We would say then go to a briefing schedule. Again, keeping it as short as possible and then ruling immediately following those briefs filed one way or the other to keep the case moving towards that trial date certainty. So judges, I think throughout the state of Ohio need to be taught that this is the best practice rather than waiting till a motion to compel or a protective order takes place. Dispositive motions should have a built-in filing date, a built-in response date, and a reply date. And once it's fully briefed, you have a ruling date, which I'm sure most of you have practiced in front of courts where they don't have any ruling date, and you just have to wait and hope that the ruling comes, you know, somehow, some time in advance of that trial date, which is advancing towards you, and your clients is saying to you, hey, I thought you told me, you advised me we should get out on summary judgment, at least on some of these claims or all of these claims. Well, I did, and we filed it, and you spent your good money on the discovery that was required to file that motion in the first place. But I got to tell you, the judge hasn't ruled. Well, why don't you call the judge and tell the judge to rule? No, you don't want to do that, because then you might get an adverse ruling if you pester the judge too much. Okay, what do? Oh, well, we start spending money to prepare for trial in the event we don't get a ruling. That's what I see happening. That's what I hear is happening. I'd like to hear from the people who say that's not really a problem if they've never experienced that, because I certainly hear it with great frequency. The parties deserve to receive the court's ruling far enough in advance of the trial date so that neither side incurs significant trial preparations. And then you have trial date certainty. We have to train our judges that they are not mediators. They are not mediators. They are trial court judges, and they have to. Their duty is to provide both sides with a date that they can rely on. And when I was working on the Common Pleas Court, I made a promise that no civil case would ever show up after the lawyers worked hard all weekend, after they flew witnesses in some cases, and showed up at the courthouse and were told, sorry, folks, we're going forward on a murder case, or worse, we're not going forward on any case but judge can't try it today. I'm sure some of you on this call have experienced that. And I vowed that would never take place. So what we would do is call, if we saw a conflict coming down the line, I'd have my staff attorney call the civil attorneys and say, this is what we're dealing with. How do you want to deal with it? We can back you up to this case. If it goes forward, it's a conflict. We could spin you across the street to another, a retired judge, if that's what you prefer, or I can give you a trial date right now. So you don't have to work all weekend and show up, and no one ever did. But I know that this still takes place. So, let's see. Everything that I'm advocating for is consistent, in my opinion, with what judges have sworn to do under the judicial canons. A judge shall perform the duties of judicial office impartially, competently, and diligently. Competence, diligence, and cooperation. A judge shall perform judicial and administrative duties competently and diligently, and shall comply with the rules set forth in the rules of superintendence, and which specifically say that a prompt disposition should be something we're all striving for, and eliminating unnecessary cost and delay. So this is all consistent with what we're required to do anyway. So here are the remedies that are currently available to litigants to address reasonable delay. I'd love to do a poll question, like how many of you have ever filed a writ of procedendo against a judge? Because that's one way you can deal with it. And I rarely see this writ, extraordinary writ filed, much less granted. But we just, last week, in a 7-0 decision out of the Ohio Supreme Court, granted a writ of reverse the 8th District, which denied the writ. And we said the writ should be granted. We reversed unanimously on a domestic relations case that, according to the facts and the final and the affidavit in the request for the writ, has been pending in Cuyahoga County Domestic Relations Court since 2017. It's gone through every judge over there who has recused themselves, the reason which I don't know. That wasn't evident from the record, but they recused themselves. Another judge was appointed by the Chief Justice to preside over the case. And after a lengthy amount of time, that judge recused himself. And now we have a new judge who just got on the case. Unfortunately for that judge, his name is on the case granting it, but he really had nothing to do with the delay. He's just brand new to the case, but the case has 71 unruled upon motions on a divorce case that's been pending since 2017. So that's the writ of procedendo. Okay, I just got the poll thing. Okay, I want to see how we're doing on timing. Okay, most of the time, what I see when attorneys are trying to deal with languishing motions, they file something like this. The request to provide the court with supplemental authority. I call this the "Hey judge, we're still out here waiting" motion, but that's what I usually see. But some attorneys go straight to the heart of the point and file a motion for judgment. Judge, please rule. Motion for judgment. I don't want to file a writ of procedendo to you. And when I was talking to disciplinary counsel about the need for this, I said to them, you know, it's unreasonable to say, oh, the parties should just file a writ of procedendo. You don't, especially if you're in front of judges that you know you're going to be practicing again on future cases. Why would you irk the judge when you're trying to get a favorable ruling? It just does not make common sense. But I think some of my colleagues, even on the Supreme Court, don't know or are aware that this is the problem that I think it is. So what I originally envisioned after talking to Colleen, and there's a standing advisory committee that I asked her to put this in front of. And they were already talking about it. Again, this practice, I didn't come up with this idea on my own. This is a practice that people have been calling Colleen for many years, and she's been calling judges to get motions ruled on. So I said, let's formalize the process. Let's have, I want the process to be anonymous, because the person who is identifying a motion, let's say it's been pending for a year with no future event on the case management order, the person who wants that ruled upon, whether it's the person who filed the motion or who opposed it, is, in my mind, in opinion, irrelevant. So why should they have to out themselves who's calling? It shouldn't matter. If a motion is over the amount of time which the court dictates, then it doesn't matter who's calling. It should be ruled on it. So it's a friendly call. Judge, I just want you to know that we've been made aware of a case that you might want to bring to your attention. Here's the case number. Could you look into it for us? And if you could you, if it is something that you there's nothing preventing you from ruling, could you provide a ruling in 2 weeks? And then the judge would hopefully say, and I've contacted probably 10 or 15 former colleagues from the trial court, and I said, if you got a call from the case management section and they just alerted you about a motion that needed to be ruled upon, would you be offended, or what would you do? And they, all of them said, I'd rule on it. I'd rule on it. I'd want to know why I didn't know about this earlier. And that's how I think most judges will take this. Most judges that I know are conscientious public servants who want to be fair and want to be seen as doing their job. If that failed, my original proposal said, let's contact them again to make sure that there's not something that happened that we don't know about. The Ohio Supreme Court contacts a judge, and then, I thought, well, if you can't get a ruling after the second call, and there's no explanation as to why, I mean, to me, it just made perfect sense. I didn't think it would, I didn't think it would get to this point, but what I wanted was, okay, we'll send the matter over to disciplinary counsel so they can send a letter, like letter of inquiry, because if there's no good explanation, that got nixed from the process. I don't know how, but like I said, this form is what has resulted, formalizing the process that already existed and giving you an alternative to deal with delay if you are experiencing it. So I see it's 12:40. That gives us about 20 minutes to discuss and answer any questions you might have. And I thank all of you for your attention.
Thank you, Justice Donnelly. I appreciate it. I see we have some questions in the Q&A box, but I just wanted to open it up with an initial question. I think most of us on the call today would agree that, efforts to maximize judicial efficiency and get rulings would be a good thing. But curious what you've, seen as far as resistance so far in some of your other discussions, or just kind of informally, or other presentations that you've given. What are you hearing as, potential pushback for why this might not be a good idea?
I have not heard a valid argument why it would not be a good idea. When my effort in 2014 failed and they tabled it for good, I would get responses from particularly from my older colleagues who had been serving for a long time. They would say something like, why are you giving the attorney so much power? And I'd say, what do you mean? Well, you're giving them this automatic continuance of the case. I said, yeah, but that only comes into effect if you don't rule. That's the only time. It's a way of self-policing ourselves. So I don't view it that way. But let's face it, judges have a lot of power in the state. And, when they say something, I want to see you at the court, they usually get what they order. To this effort is just showing the same respect to the litigators and their clients that we expect of them. Other states are using this effectively. In New Jersey, like I said, they have an automatic continuance rule there. In the federal system, a friend of mine, a federal court judge, told me that what they will do, based on some reform legislation that was passed about a decade ago, the names of the district court judges who have motions pending over a certain amount of time actually get transmitted to Congress, and they're on a website, and it becomes a public record, a list of judges that have these unruled upon motions. And Mark Godsey from the Innocence Project tells me that there's habeas motions pending in federal court where they've been pending with no future event date for in some cases for five years. But this judge told me it's pretty effective when you have a list like that basically comes out, a list you don't want to be on, a judge who's not doing their job, basically, is what's taking place. So if there is a valid argument against this, I haven't heard it yet.
Fair enough. I'm gonna take a look at our Q&A here and see if I can pull some questions. All right, so the form speaks in terms of requesting status. Will trial judges be expected to provide more than, quote, the motion is pending and will be ruled on soon, end quote?
Yeah, I mean, good question. When I first talked to Colleen, she said, we do this, but let's face it, we don't have a unified court system. We don't really have the teeth that we would need. That's why I wanted the 3-step program that ultimately would result into a referral to disciplinary counsel, that I don't think in most judges would ever get to that stage if that process was in place. But yeah, why it's out for public comment, the court wants to hear what you think about this. And why I'm doing this webinar is because I didn't want this to fly under the radar of everybody without having an opportunity to think about it. I strongly believe that the identity should be anonymous, and it shouldn't be limited to the attorneys. If the client is upset about an unruled upon motion for summary judgment, they should be able to call and have it done. The feedback that has already come back, most of it is overwhelmingly positive. There's some that say you're opening a can of worms here, you don't know what you're doing. There's some saying, isn't this actually ex parte communication with the court? And I don't think it is, because it deals purely with a procedural issue. You're not telling the judge how to rule. You're telling the judge just to rule. Did this fall through the cracks? And it's not often, delay happens in our state system, and it's not often about, just a judge who is not competent. Sometimes it falls through the cracks because various jurisdictions in our state don't have the same resources. In Cuyahoga County, we have a case management system that would provide you with electronic ticklers when something needs to be ruled on. In rural areas, they don't have that. They use the old-fashioned Post-it note on the to try to keep them in line when they have to timely rule on something. And we have to file these forms and send them once a month as trial court judge down to the Supreme Court, and we're supposed to list how many motions are pending on your docket over 120 days, but there's no oversight on that. They go down to the Supreme Court. There's no one who verifies that. There's no verification of that. Other than the judge's signature. And I have collected anecdotes over the years of extreme cases of delay. A bench trial that was filed in 2000, or that took place in 2004, and the verdict didn't come out till over a decade later. When I was practicing at Davis and Young in insurance defense, there was a judge, a one-court judge, no longer on the bench, in Northeast Ohio, not in Cuyahoga County, but that reputation is where that judge's docket is where summary judgment motions went to die, because they would be filed and they'd be opposed and there would be no trial date and nothing. They would just languish up there. And, we'd drive up at a court order status conference or, judges trying to settle it. But every litigator on this call knows that the only way you're going to get it settled is if you have a trial date. And a uniform case management order, in my opinion, would allow attorneys to do what attorneys do best, not judges. Attorneys do best when they have a firm trial date certainty and they can assess the merit of the case or the lack of merit of the case. And the sooner they can get to that point, if the judge is managing the case correctly, they can provide their client with sound advice on whether do a cost benefit analysis and say, we should settle this case, and this is for how much, or we should go to trial, one way or the other. That's what I wanted to teach our new judges who are taking the bench.
We have a couple questions that came through regarding, the anonymous filing process. Try to combine these. One of our viewers is concerned that if you are the one who has the pending motion and you're asking for a ruling, even if you're doing it anonymously, there's going to be a situation where the judge is going to know that it was you who filed the case flow request because you're eager to get your ruling, and kind of the potential impact from that. And then, the other part of that is, how are we going to have a check on who is able to file the request? You mentioned clients potentially being able, but what's to stop a newspaper or some other media or just anybody who's kind of following or interested in a case from filing one of those case flow requests?
Yeah, so we've talked about this, and I know the advisory committee dealt with this. Like, isn't the judge going to really probably know? It's probably coming from the defense who filed it, who wants this, and that same fear of receiving an adverse ruling is going to be present if this thing gets up and running. But we think if it gets accepted as a prospect, that, and there may be some rulings that some judge wrongly denies the motion for summary judgment that should be granted because he's irked that someone does that. We think that'll be few and far between the vast majority of the judges, but that might happen. But what's the alternative? Your client's still going to bear those expenses and maybe pay out unreasonably on a case that you should have won on summary judgment. So there's really no way to alleviate that. I think it should be anonymous. I'm going to advocate for that on the identity. And then what's to prevent a paper from doing it? Well, we don't have enough transparency from the media right now, in my opinion. Think of an innocence case. And there's innocence cases that I know out there where there's no future event date, no future hearing date. There's just a motion for a new trial and a brief in opposition. And there is nothing set on the horizon. And I think the media should be able to call on this. Like, why isn't this case being set for a hearing? Or why haven't you ruled one way or the other? This person's claiming they're innocent. If it's true, the state's going to have to pay out, if they're able to establish that, in compensation for every year that they were held if the human misery of having an innocent person doesn't move you, then what about the taxpayer money that is going to be paid out? I mean, to me, wrongful conviction is the worst form of injustice that can occur in the system, and we should do everything in our power that when it occurs to resolve it. But I think that's something to be considered in the person who posed that question. And I encourage, you can comment. You don't have to do a formal letter. You can just do an email if you have some concerns, if you have some questions, and particularly if the litigators on this call have anecdotes of, I could tell you a time when I had something that was unreasonably delayed. And these calls aren't going to be made with, it's 2 weeks beyond the 120 days. This process is designed to address unreasonable delay or unexplainable delay. When I had a ruling date built into my case management order, I found it very effective because sometimes as we approach that ruling date, the parties would engage in settlement negotiations before that ruling date. And they would call me and they'd say, hey, Judge, we made some real progress in settling this case. Would you mind withholding your ruling for 10 days as we continue to make progress on this? And I'd say, absolutely. A joint request that has been filed to be extended, and most of the time they call me and say, Judge, we settled the case. Great. That's it.
Through a couple more of the questions here. We've got a few more minutes. Is the Supreme Court working on other initiatives to address the root cause of delays, such as the lack of resources for rural courts, lack of good project management skills within a common pleas court system?
Yes. With Colleen, I've discussed a series of building up a series through the Judicial College. Repeated. I'd like to see them repeated every year because you have people leaving and joining the bench every year. So this is not something that you can just do once. I think it should be built in as required curriculum. The Conviction Integrity Task Force is about to release its report. A big issue that they deal with is the same delay that we described in this program. And we have proposed a new rule that hopefully will be implemented that requires judges to have hearings when a motion that is not frivolous on its face has something claiming new evidence exists or some form of evidence or a recantation has to take place. A hearing is going to be required if this rule is passed. And that's not required right now. Judges can just simply rule on the motion. You could file a motion for a new trial and say, the main witness and the only witness who convicted me has just recanted. And here's his affidavit. And the state opposes it and says, that person's untrustworthy. Well, maybe that's correct. But how do you determine that without a hearing? But judges are denying motions for a new trial without a hearing. And then that person who's claiming they're innocent has to go up to the Court of Appeals, spend 3 years convincing, and they usually do convince the court as, hey, you got to have a hearing on this. There are tons and tons of cases where this is occurring. So that's another effort that's taking place to deal with delay. And resources it was asked about. This is something that needs to be dealt with the legislature. And we are, through the Sentencing Commission and talking with various legislators about this problem.
Just a few more. I'm going to try to squeeze in 1 or 2 more questions here if I can. Someone asked if the new process is only going to be applicable to the common pleas court, or is it going to apply to municipal courts as well?
I think it envisions all courts.
Can the Supreme Court collect data on pending motions the same way that they do with the disposition data? Perhaps when the case is disposed of, the reporting time between motion and ruling from summary judgment motions.
I
Is
would
that
certainly,
something?
yeah, I would certainly like to do that. We do collect forms that are required to, that should have those data there. We should be able to compile that. And I know Cuyahoga County, to its credit, they have a website with various dashboards showing resolution time in their cases. And, you know, a lot of judges over there are doing fantastic jobs in getting great resolutions in a timely fashion, but we don't have it centralized or a statewide database that collects that type of information. And again, we don't have the oversight to verify the accuracy of what's being reported. So, but I would love to see, I would love to see something like that in the future.
This might have to be our last question, and I just want to make sure before we end, if you could just provide everyone with a reminder of how they can provide comment on the proposed rule and the proposed form, just so everyone's clear if they didn't get a chance to insert their comment or have their question addressed.
Okay.
So last question is going to be, isn't it asking a great deal to ask the judge to allocate the necessary time to thoroughly review and rule on cases that are complex, with complex facts and law and hundreds of pages of briefing and supporting exhibits? It seems to me the judges are doing triage all the time, and complex civil cases tend to stay at the bottom of the pile. Do you hear this from judges? And if so, is the response simply to make the time and do your best? A lot going on there.
Yeah. Okay. Well, that's a great question. This is why I have always been an advocate for commercial dockets, because complex litigation, as described in that question, needs to be managed in a different way than your average simple civil dispute. Complex litigation is the litigation that is most likely to have the most discovery disputes. So the judges really have to stay on top of those discovery disputes. Yes, they're complex. That's why the court allows for additional time to resolve those cases. But it doesn't mean that those cases shouldn't have a trial date and trial date certainty and ruling date certainty, just like any other case. One of the questions that came into Colleen's office said that, you know, some cases just take a long time. Okay, I get that. But, you know, judges who handle commercial dockets need to be trained in a special way to provide those parties with the same degree of trial date certainty and ruling date certainty that they deserve. Otherwise, if you don't have that, you have parties resolving cases that they don't think they should against what they think the merits of the claim with money, and they come away with a lack of confidence that the system is working as it should.
Well, we've gone over just about a minute. So I would encourage everyone to please, if you have any additional questions or comments, to please utilize the public comment process. I believe we had sent the information along with the invite on that, but just Donnelly, if you want to remind everyone of that process, just so they hear it from you.
Yes, it's Colleen Rosshirt, and that's spelled Rosshirt. She is manager of case management section at the Supreme Court of Ohio, 65 South Front Street, 6th floor, Columbus, Ohio, 43215-3431. And if you have any additional comments, questions, my door is always open So anybody on this call, I thank everybody for participating today, and feel free to contact me directly.
Thank you so much, Justice Donnelly. We appreciate your time and your initiative here. I think it'll be well received amongst the group and hopefully across the state.
Okay, thank you.
And thank you all for your time today.
Thank you, everyone. Thank you, Freddie. Great job moderating. Everyone, I will get the materials out to you as well as that CLE survey I mentioned earlier. Thank you for tuning in, and we'll catch you next time. Have a great day.
Thank you.
Take care.
Thank you.
Bye.